Hello everyone, we are going to start lecture number 29. Till lecture number 28 we have completed all the fundamental rights which were subdivided into lecture 28.1 2 till 15. We have went away. Okay, now in this lecture 29 we are going to discuss about writs. Okay, and this lecture will also be divided into subparts because within the writs there are many concepts like habeas corpus, mandamus, prohibition, certiorari. So what are those things? So we'll discuss in detail. So first we'll try to understand in this lecture number 29.1 that what exactly do we understand by the writs. Even you google it, writ is nothing but a legal order that someone has to do or not to do. Okay, this simply means that. Now for the enforcement as per the Constitution of India, we'll try to understand, like for the enforcement of the fundamental right, whatever we have seen in the lecture number 28, as what this is the fundamental right. What is this? This is a part 3 of the Constitution. So whatever we have studied in the fundamental right, so for the enforcement of that fundamental right, the judiciary has been armed with the power to the issue the writs. Now this writ is the power of who? Of judiciary to enforce what? To enforce this fundamental right. Okay, so through writs judiciary get the power to enforce the fundamental right. Okay, now this power to issue the writs for the enforcement of the fundamental right is given by the Constitution of the Supreme Court. It was through the article number 32. What we have seen in the article 32, we have told that clearly that this article 32, right to constitutional remedies, is there within the article 32, and this article 32 is nothing but called as the soul of the Constitution. It is called as the soul of the Constitution. Now using this article 32, Supreme Court gets the power to enforce the fundamental right to every citizen. Now so the power to issue these writs for the enforcement of the fundamental right is given by the Constitution to whom? To Supreme Court, and who? It is High Court. Supreme Court and the High Court has given to the power. Okay, now what is this? Supreme Court has the power. Supreme Court has the power to issue the writs only for the purpose of the enforcement of the fundamental right, whereas like this writ can be used, whatever the writ will be there, this writ can be used as a power. This writ, the power to issue the writ, is only big, only with the bold letter, is only for the purpose of enforcement of what? Enforcement of the fundamental rights. Okay, fundamental rights. Whereas this is whatever I have told you, this was with respect to Supreme Court. This was respect to the Supreme Court. Now what about High Court tells? From where this High Court gets the power? Okay, from where this High Court gets the power? High Court gets the power through the article 226. High Court gets the same power through the article 26, that High Court can also issue the writs. High Court can also issue the writs for the purpose enforcement of the fundamental right and for the redress of this one. Whatever the things I have discussed, that will be applied to the High Court, and for the redress of any other injury or illegality. So the only difference is that this Supreme Court enforce this power through the Article 32, and this High Court gets the power to issue the writs and all. It is through the Article number 226. Okay. Now Supreme Court can issue a writ against any person or government within the territory of India. Now the difference is that, one difference is that Supreme Court enforce the fundamental right, it is through the Article 32 it gets the power, and High Court issue it is through the Article 226. That is one of the difference. And another difference is that Supreme Court where is that Supreme Court can issue writ to any person or even the government, even to the government. Okay, to who, to what is the territory defined for that? Territory of India, whole India. For whole India, whatever the territory of India, Supreme Court can issue the order for that, issue the writ for that. Okay, but High Court can do for their only defined region, okay, into their territorial jurisdiction. So High Court can issue a writ against a person, government or authority only if they are located within the territorial jurisdiction of the High Court. So for the High Court, the difference is that territorial jurisdiction, to till which the High Court has the power, like Patna High Court is there, Assam High Court is there. So whatever the writ will be issued, that writ will be issued for the only that region. Let us suppose the writ has been issued within the Patna High Court, so that writ will be applicable to that region only. Okay, but Supreme Court can do for all over India, for whole the territory of India. So this is about the intro of the writ. Now there are various types of writ. Okay, among that writ there is habeas corpus. Okay, so we'll discuss. Let us discuss that habeas corpus also. Okay, habeas corpus. Okay, now what is this habeas corpus? See, this habeas corpus tells that a writ of habeas corpus is called upon the person who has detained another to produce the latter before the court in order to let the court know on what the ground he has been confined and to set him free if there is no legal jurisdiction for the imprisonment. The word habeas corpus literally means to have a body. This writ meant it has to be addressed to an official or private person who has been another person in the custody. So what is that? We'll see. So like if any person has been detained or arrested, his body must be produced in front of the court. Okay, so in order to, this habeas corpus literally means to have body. Okay, now in order to protect the individual, freedom, and is used whenever person is detained or illegally. Let us suppose a person is detained illegally. In that case also this habeas corpus come into play. Habeas corpus means, just to understand, take it like if you want to remember, if you are forgetting, just remember that habeas corpus means to have a body. Now what does it mean? Person can file habeas corpus petition, then the court will ask a person, let us suppose person can file, let us suppose your brother is missing, or your brother has been detained illegally by the police. So I am going to the court and I have filed a habeas corpus petition. Then the court will ask, to whom? Court will ask to the police, show us the body of the individual. It may cause you to release even before going to the court. Like even if the person is going before the court, okay, the police may release by fear. Okay, so let us suppose my brother has been detained illegally by the police. I went to the court and I have filed a habeas corpus regarding that scene. Okay, writ, I have found a person for the file habeas corpus petition. Now court will tell the police produce the body in front of us, and because of that fear, because this has been illegally detained, it is against the right to life. You are snatching the fundamental right of the individual, and court can give a heavy punishment to the police for that. Okay, the police also have a fear for such scenario. So it can also happen that before producing a court, police by fear the person, they can release that person. Okay, so because after producing in front of the court will ask various questions to the police which can be uncomfortable to them, which can be uncomfortable question to the police. That's why police can even release that person before producing to the court. So see the power of this kind of writ. Okay, habeas corpus is not only valid to the state, okay, but also to the citizen of the country. It is not within the state. Let us suppose that this habeas corpus is valid. Okay, okay, it is throughout the citizen for the country. Now let us suppose I will give you an example. A girl is there of 18 years, okay, is detained under his house. She has been detained, let us suppose, by his parent. Okay, by his parent a girl has been detained. Now his boyfriend, the girl's boyfriend, her boyfriend can file a case under the habeas corpus petition. Under habeas corpus, this is habeas corpus petition, okay, against that family, against that family. Now private citizen can also violate the fundamental right of someone else. Like, it is not only that government or police is going to violate that fundamental, even your parents can violate the fundamental right of yours. In that case also the family will be punished. Okay, you can't someone detain illegally. Okay, now one question is that within the habeas corpus that I was telling you, that we have seen that the person who is facing offense on him, he can't himself go to the court. Okay, he can't himself go to the court, or himself or herself go to the court. He can't himself or herself can file a habeas corpus because that person is already detained. He is not allowed to go outside. So how he can file the habeas corpus? So there is a concept called locus standi. Here is a concept called locus standi. It means that only I can file a case. This means that, okay, it means that only I can file the case. Now here in the principle, here in this habeas corpus, this locus standi does not apply, because the person is already detained. So your friend, your relatives can go to the court and can file a petition under the habeas corpus for the person if it is illegally detained. So the court will ask, produce the body in front of the court, and if, let us suppose, if the bodies have been produced to the court, then there can be a multiple question that the person can't be able to answer. So that's why many times people used to release that person if any court, if it is found that someone is going to file a habeas corpus petition within the court. That, see how much powerful this is. And habeas corpus does not apply locus standi. Locus standi means only I can file. There are writ where locus standi applies, we'll see. Okay, but in this habeas corpus, this locus standi does not apply, because the person to whom this this habeas corpus will be applied, that person is already in detain. He is already detained. So that's why locus standi will not work. So this was all about in this lecture. Then we'll proceed to the mandamus writ. Okay, thank you.